I will never play this game with you again. No means no. Do you know why you're here, Mr. Robinson?
Judge, I do not.
Think. Do you know why you're here?
My mama said I've been bothering her or something. That's the only thing I can assume. I honestly do not know, Your Honor. I've been doing my classes, just thought about probation, and trying to do good.
You are on probation for harassment. Can I give you a cause number?
Yes, please.
It's 247-4460. Mr. Travis Robinson was placed on probation for harassment in March of this year. What did we ask you not to do? Right. Have you been bothering her?
A child together. I think she must have not liked that I was trying to ask for my FaceTime that is from child support orders. And I guess she must have thought I was harassing her from continuously asking or calling to get it. And I think that turned into harassment. It was nothing towards her.
What does harass mean, Mr. Robinson? Over, over, and over, and over, and over. You can read the jury box. I'm gonna get you a lawyer today.
So right there.
Just point someone to Mr. Robinson, please. We need to have a hearing on this. I'm going to forward you something, Pavel, real quick. Okay, John D, tell me. What's up, bud?
Always good, sir. Always good to see you. I'm pushing on a newly appointed case, Mr. Robinson. He is on a defer for harassing people.
Oh, okay, got it. You
And
got
I
it.
talked to the chief, and it looks like there hasn't been a formal motion yet, but that's
I have
coming.
one right now.
Okay.
I need to email this to you first. So I want you to look at it and then talk with him about it.
Okay. I will revisit you on that one. Let me look at everything.
Let me send it to you real quick.
JD Law.
The way it'll work.
So it is JD.
JD Law.
Got it. All right, I'm forwarding this to you now.
Absolutely.
Yes, Andrew?
Oh, I'm sorry. Come on.
No worries, Judge. We were talking about that anyway. But Judge, I did Mr. Robinson, Travis Robinson, on Judge. According to Mr. Robinson, he's been complying with the non-threatening harassment on this particular situation. Per the Attorney General's office and part of his compliance in child support, he gets 15 minutes of FaceTime with their mutual child. And that's all he was trying to do, was just to try to call her so he can get his 15 minutes. Now, that's what he's telling me. I have no way to verify.
The judge's patience is gone. This is not a game, and it will not be played again. The man stands before the court insisting he's been trying to do better, following classes, staying on probation, believing his intentions were clean. But the record tells a harder story. He is here for harassment. Repeated contact. Over and over. What he calls a right to FaceTime his child, the court sees as a boundary crossed too many times. The tension thickens as a lawyer is appointed on the spot, signaling this is no longer a warning but a serious turning point. Paperwork moves fast. Voices lower. The lesson is clear and heavy. Probation isn't about intent. It's about compliance. And when no is ignored, consequences follow.
Verify any of that, Judge. I just heard all of that this morning. But, you know, it kind of makes sense to me. I showed him the video with him calling from 7:30 to 7:45.
I already had, so I had a lengthy conversation with him prior to getting on probation that in the event she failed to comply with what he was able to get as far as FaceTime, that he was to go to the family court and use them as the avenue to either hold her in contempt, have her fined, jailed, whatnot for non-compliance with their custody agreement.
I agree, Judge.
He was not to take matters into his own hands.
Well,
And now,
all I can show you is based on the call logs that she screenshot over and I looked at, what you sent me. It shows that from 7:32 to 7:40-ish something, that he made these series of calls. There's no way we can tell because she declined all the calls. And I said, well, you know, you're calling a lot. And he goes, yes, because I was trying to get through the FaceTime so I can talk to my child as part of my child support compliances. That's all I was doing. I never made communications to her, didn't even have words with her.
20 calls in a matter of 3 or 4 minutes.
But if you're trying to get to me, it's reasonable, Judge, because he's trying to get through.
Many times is not reasonable.
Well,
Come up, Mr. Robinson.
if he was trying to get through FaceTime, he would keep trying because he only has that allowed time to get through to see his daughter.
I told you the last time you were here that in the event she was non-compliant with your custody arrangement, you were not to take matters into your own hands with the repeated 20 to 50 to 150 phone calls that you do. I have proof to the contrary, Mr. Robinson. And if something is happening to where she is busy, that she cannot get a hold of you, how do you know that she's not having a crisis of her own? For you to call 20 times in a matter of a minute or two is harassment.
Think of situations. Like she could have been busy. Baby could have been sick. That's why she didn't.
Now it's a little bit too late.
Myself instead of.
Ma'am, he goes with you.
The judge makes it clear that the issue is not intentions but behavior. Despite prior warnings, Mr. Robinson repeatedly called the complainant, more than 20 times in just a few minutes, claiming he was only trying to reach his child for a court-ordered FaceTime visit. The court rejects this justification, emphasizing that when visitation problems arise, the proper remedy is family court, not taking matters into his own hands. Repeated calls, regardless of purpose, amount to harassment, especially after explicit instructions to stop. The judge notes there could have been legitimate reasons the calls were unanswered and stresses that excessive calling shows poor judgment and disregard for court orders. Although defense counsel later argues Robinson is remorseful, employed, and fearful of losing his job, the court remains focused on enforcing boundaries, making it clear that continued violations will result in immediate and serious consequences.
Bye-bye, Mr. Robinson. You didn't get it last time.
Yeah,
See if it happens this time.
So let me figure it out.
Ma'am,
Talk to you soon.
ma'am. Don't set him down, please.
Take care of the phone, Judge, and then I'll come back.
I'm gonna scare him.
You want to let him think about it?
Give me 30 minutes.
But I've talked to Mr. Robinson. He is truly remorseful. He knows he didn't make the best judgment. He did get a new job at Cracker Barrel on the town center in 59. He's terrified that he's going to lose it. He has to go to work at 9 in the morning. His mom is actually waiting.
Mom's here?
No, she's in the car downstairs waiting on that. So I told him that I would. I just wanted to kind of update you what I found out more. he is, in terms of
Problem,
AG and
complaining witness is absolutely fed up with him calling and calling and calling. And how many, do you have the case pulled up?
Judge, if we, give him amended conditions like 0 tolerance, 1 too many times, and he's going in, anything, I saw it, Judge, I get you. But again, if there's this FaceTime thing that he's just trying to see his, see his daughter. But, why don't you just say, besides the no contact, the FaceTime, just don't have any communication with the ex, and that way they have some space, and he's only allowed to call during the FaceTime. And if that's not possible,
the problem is that Shatoria, what exactly did we tell him that he was not allowed to contact her only for purposes of the visitation? What do we do now?
But I think it's harassing or threatening.
Well, that I know. Yeah, because it.
The 4066.
I'm trying to pull it up right now.
4066.
Yeah. Sorry, man. I'm trying to pull it up. 247-4460. That's, maybe no contact except for the time.
I don't think he's incapable of having contact without, so maybe we should just do no contact at all.
Yeah, that's what I was saying. That no contact except for the.
Didn't add anything about.
All we did was just no threatening, harassing, abusive contact, and that's obviously.
They have as part of his child support, he has 15 minutes of FaceTime, and that's the time.
Do you have?
The judge reaches a breaking point. After repeated violations, excuses no longer matter. What's clear is that boundaries were ignored, warnings were brushed aside, and trust was lost. Excessive calls, even when framed as parental concern, crossed into harassment and showed an inability to follow court orders. The court makes a hard decision. All contact stops, effective immediately. Not as punishment, but as protection for everyone involved. The judge still acknowledges a father's right to be part of a child's life, but only through lawful, controlled channels. Until a clear, written plan is presented and approved, silence is mandatory. One more mistake will not bring another warning, it will bring jail. This time, the message is unmistakable.
Okay, so were you, I'm now going to modify the conditions, no contact whatsoever.
Yeah, exactly.
He's incapable of doing it without, unless, so now I can't trust him anymore, so just no more contact. He's going to have to find another way to have contact with the child.
And if he doesn't want to sign,
Well, then I'm going to put him in jail. I'll keep him. That's it.
Judge, we have a
Tell me.
possible solution.
Well, I was going to say just no contact. It's okay, Kevin. Tell me what you're thinking.
Is there an established time that he is supposed to contact because if she's just willfully withdrawing, not allowing you?
I don't know. We don't have.
I think there is. I think it's that during that time frame.
Can you, from him now, get a copy of the custody order, or perhaps I can look at it?
I don't have that, but maybe what we can do is bring him back and tell him to bring all that and set a very specific time for that contact, only to be for the purpose of parenting the child.
Okay, I'll agree to that. But until we're able to formulate the plan, no contact.
Yes.
So
how about if we bring him back later this week, give him a chance to give me all that stuff, and I'll work with, probation to put that in place. Would that be okay?
Yeah.
All right. Should we bring him
am I
out?
grabbing him, please?
Thank you, Mr. Norton.
Every father should have the right to have access to their kid, but you can't do what you're doing. I mean, that's just not cool. That's not cool. Now, if she is truly withholding, you have to find the right avenue to do it. Calling 100 times is not it. Tell me while we're waiting.
He went and tested negative for everything.
Wonderful.
And he
Good
is,
job.
so,
Keep it up.
um,
Or just, I guess, have him wait right here and then I'll talk.
Alright.
I will never play this game with you again. If you and I see each other again, I'm assuring you a very lengthy jail sentence. No means no. Doesn't mean maybe. Doesn't mean she's got my kids. There are proper ways to fight someone who doesn't want to give you access to a child. Calling 30 times, 50 times is not the way to do it. We are going to try to formulate a plan to help you.
The judge makes it clear that the court's goal is not to cut a father off from his child, but to stop behavior that only makes the situation worse. The judge explains that repeatedly calling dozens of times is not helping. It is alienating the child's mother further and pushing her to restrict access even more. The court orders the defendant to bring a copy of the custody and visitation order at the next hearing so the judge can see exactly what was legally allowed. A structured plan will be created through probation, including a specific, limited time for contact, with the probation officer acting as the point of communication so there are no misunderstandings or violations. The judge warns that if the mother later withholds access despite a clear court-approved plan, the proper remedy is family court, where she could be held in contempt, not harassment. Until that plan is officially set, the order is strict, absolutely no contact. The message is firm but corrective. The court is offering a lawful path forward, but only if the defendant follows the rules exactly.
Mr. Robinson, until we have done that, I don't want you to have any contact with her whatsoever. Do you understand? What we're going to do is we are going to postpone your case until Wednesday.
Thursday, Judge.
I'm gone Thursday. I'm not going to be here.
Friday?
I'm not here Friday. I'm gone. I'll be with a bunch of 12, 13-year-olds in San Antonio.
Will you come back next week, next Monday? I'm just trying to, because I
I'm okay with that as long as he realizes that you cannot have contact with this person until Monday.
But next week.
I'm okay with that, but no contact means no contact, Mr. Robinson.
That's the 6th, May 6th. That's when we
I will do whatever.
Monday's good. I'm off on Monday.
Then Monday it is. But this is what we're going to do. I want you to come back Monday. I want you to bring me a copy of your custody and visitation order. I want to see what the judge set forth as you being able to have access to the child. We will set a plan in place because our probation officer has the ability to contact Michaela. We will try to set forth a plan so that you can have access to the child without you having to call as many times as you have been. All you're doing is you're alienating her even more, where she's going to restrict further access. You're going about things the wrong way. Do you think someone wants to have them contact 50 times? Right. Do you think that's going to have them resent you more? Yes. So, we're going to try to create something for you. On Monday, when you come back, bring me a copy of the order. We'll see what the judge said as far as time is concerned. We will also reach out through the probation officer to her to make sure that she knows this is the proper time. He will only be able to call you at this time so that there are no issues. And if then she continues to restrict your access, somehow we will help you get to the family court so that you can have her held in contempt for willfully withholding and violating the court order she's got and you have. Do you understand? If at that point she still is giving you, if she's not giving you access, you go to the family court and they will hold her in contempt. Okay.
Thank you, Judge.
No contact until we get something set up. Okay? All right. You can, please.